International Financial Center has been created to promote Kigali as a platform for financial innovation and financial investment in Rwanda, but also across Africa. And it has had a very good start and been able to attract a number of noticeable players already, and is continuing to do so.
The Kigali International Financial Center is coming within a context of rapid economic growth in Rwanda. Today, if you want to do business across the continent, we offer you Rwanda as a hub. You come here, you set up your business here, and then you can expand to the rest of the African continent.
In terms of untapped opportunities in Africa, we have access to expand. Yeah, we have a very large untapped market, can be catalyzed by technology today. Africa has the highest mobile penetration. That is in itself a really good opportunity to transmit those financial services.
We are in the middle of the digital transformation. We have new ways how to interact with finance, with our fingertips on our smartphones. In the financial industry, we call it fintech, financial transformation. This kind of trends, we have a big impact in the future.
Fintech is a key component of what we want to do in Rwanda, and that will have positive externalities for Rwanda, but also for Africa.
There are certain areas that require our attention in society, where we haven't solved problems. And the one is financial products for young people, where you don't necessarily require collateral and where someone's financial background doesn't play a role. As an organization and as a founder, I believe that you need to stay as close to impact as possible. That's why our headquarters are based in Rwanda, because most of the students that we finance are based in Rwanda. So it's natural for us to want to base our fund in Rwanda.
One of the advantages investing through KIFC has is having those DTAs with fellow African countries helps to ease business entry from Rwanda to the rest of Africa. And having a young team of professionals whose single focus is to help you set up your business has been one of the most beautiful experiences I've had worldwide doing business.
One of the critical factors here is having a credible framework that the market will accept. We mean the right laws. We mean the right regulations. We mean the right approach to compliance. And Rwanda, at great speed, are passing these laws. And that's very encouraging to see.
When it comes to Africa, Africa is a growing market. Now, recently, 55 countries of Africa have decided to embark on the continental free trade area, which is the largest globally. And this makes even more attractive Africa as a destination for investment.
This is a game changer for the continent for a number of reasons. First, there will be increased focus in the trading of value-added products and services. There will be the benefit of comparative advantage as well between countries. There will also be the benefit coming from the fact that intra-African trade transactions will be settled in local African currencies.
The financial sector plays a key role in the functioning and the development of any economy. That is the place where people who are innovators and entrepreneurs and who need capital meet the providers of capital. And there can be no economic growth, no successful businesses if that connection is not done effectively and efficiently.
Financial innovation is key to unlocking sort of our economic growth on the continent. And the fact that Rwanda is leading that is again showing how it's being sort of a beacon of light around financial innovation. Making Rwanda a financial center will have a significant impact for the region.
This is Africa's turn. It's happening, and the financial services is at the heart of that. It's the lifeblood, it's the heart, it's the lungs. I mean, any metaphor, analogy you can take, financial services is indispensable to finally lift Africans out of poverty, provide them with the jobs they need and the prosperity they need.
My name is Giselle Dukuze. I'm the Legal and Compliance Officer at Rwanda Finance Limited, and I will be moderating this session. We're pleased to have you today in our 5th session of Fired Up for Finance series. Today's discussion will be around the new law governing trusts. The discussion will be mainly to highlight the new additions brought by this new law, the establishment, functioning, and importance of trusts. We have with us today a very interesting panel, mainly composed of the practitioners who will be sharing their experiences, their insights about this new law. I will start from my left. We have Eric Chaga, who is the managing partner at Case Solutions and Partners, where in his day-to-day activities, he ensures the legality of commercial transactions, advise companies and individuals on their legal rights and duties. Eric has a deep understanding of the aspects of contract, securities law, insolvency, business organization, and employment. Eric holds an MBA from UK. He is a member of Rwanda Bar Association, an accredited arbitrator, a certified adjudicator, and member of the Chartered Institute of Arbitrators. He sits and seated on quite a number of boards in different institutions. He is a newly elected vice president of the service cluster within the private sector federation. Eric also is the honorary counsel for Côte d'Ivoire in Rwanda. Eric, we're pleased to have you today. You're welcome.
Thank you so much.
Right after Eric, we have Molly Rigamba, who is the managing partner at RR Associate. She is a corporate and commercial lawyer with a vast experience in financial sector, including banking, insurance, and other financial products. Molly is a licensed attorney and arbitrator. She is, in her day-to-day activities, she works on a number of projects as a legal advisor and a counsel, conducting legal due diligence, legal audits, corporate restructuring, mergers and acquisition, trust and corporate services. She also provides legal drafting support to the government institutions, and her latest project was in the investment law, where he was working along with the KFC laws and regulations. Molly also sits in different boards as a board member, and she holds a master's degree in international comparative law from Sweden. You're welcome, Molly. We are pleased to have you today. Okay. Right next to Molly, we have Odethi Birungi, who is the analyst in legislative drafting and translation at Rwanda Law Reform Commission. Prior to joining Rwanda Law Reform Commission, Odethi worked for the Ministry of Justice as a principal state attorney in charge of legislative drafting. Prior to joining the Ministry of Justice, she also served as a prosecutor for quite a number of years. Odethi holds a master's degree in advanced legislative studies from London, and she also holds the diploma in legal practice from ILPD. We are pleased to have you today, Odethi. You're welcome.
Thank you.
Last but not least, we have Dr. Adelit Sabimana, who is the technical advisor to Rwanda Finance Limited, where she advises on policy orientation for the development of Kigali International Financial Center. Dr. Adelit has quite a number of years of experience, close to 14, in public finance management and strategic consulting. Prior to joining Rwanda Finance Limited, Dr. Adelit was the economic advisor to the Minister for Finance and Economic Planning in the government of Rwanda. Prior to joining also the Ministry of Finance, he had been working in private sector as the Chief Internal Auditor at Access Bank Rwanda. He has been the team leader of the Office of the Auditor General for the State Finances in the government of Rwanda, and also worked in private sector as credit analyst, mainly in Cogebanque and Union de Banque, the Banque Populaire du Rwanda. Dr. Adelit sits also on different boards in different institutions. Dr. Adelit holds, of course, PhD in economics from Nelson Mandela in South Africa. You're welcome, Doctor, on the panel.
Thank you.
Okay. Thank you so much, our panelists, for accepting our invitation. And for our audience, we want this session to be very interactive. We'll be discussing and we'll be receiving your questions towards the end of this session. And I think without further ado, allow me to start with you, Dr. Adelit. Yes, Dr. Adelit, I would like you to explain to our audience why has the trust law been reviewed and repealed? what are the key amendments brought in by this new law, this current trust law, and briefly explain to us the trust, speaking about its establishment, validity, and functioning.
Yeah, thank you, Giselle. Maybe for the audience to see how this trust law fits, so the work we have done fits in the bigger picture of the ambitions of the government of Rwanda. The government of Rwanda approved the establishment of the Kigali International Financial Center in line to achieve the target of the Vision 2050 and the Vision 2035, where Rwanda is aiming to become a middle and high-income country. So to implement that government decision, the government of Rwanda commissioned the study to see where to start to achieve, to implement that government decision. So then the study informed that among key findings was to review and amend the registration framework in Rwanda. So a number of laws have been identified. The law governing trusts and trustees was on the list of those laws to be amended. So the objective was for the Kigali International Financial Center to offer a legal instrument which we believe is at par, have provisions equally among the legal instrument we can have from other financial institutions. So if we have a trust law in Rwanda, so we have the same provision, the same trust law from other financial centers. So is where we actually reviewed and amended the trust law. So the key changes, I can say that in this new trust law, it has provision which recognize the creation and enforcement of the foreign trust law in Rwanda, for example. Also, the way the law is drafted, it gives a broader scope. So before, the law was mostly having a provision concentrating of controlling the power of the trustee doing investment. So now the law, it gives a wide use so that even the promoter of trust can actually use the trust to hold assets, for instance, for benefiting person in succession. So that was actually to widen the scope of the law. Number two, in this law, we also make sure we have provisions which comply to international standards, the OECD requirement and the FATF for ML safety. So there, all trust instruments will be registered with the Office of the Registrar General. Also, the trustees will be required to register the property which are in those trusts. Number four, the trustees will be required to request a license from the National Bank of Rwanda. I think those are the key changes we have brought in this new law. Thank you.
Okay, thank you so much, Dr. Adelite, for sharing the journey of having this new law, the law amended, and also for mentioning that you've been, in drafting this new law, there have been a consideration of international standards and meeting and complying with international standards in general. Thank you so much, Adelite, for sharing the whole background. Let me get to you, Molly Rigamba. Adelite was mentioning that the assets of a trust must be registered and all of that. So I would like you to share with our audience to explain a little bit about what properties are considered as properties of the trust and the legal owners of the trust, who are the legal owners of the trust, and why does the law require the property to be registered with the Registrar General, and also the trustee is registering the trust instrument with the Registrar General, and why would the property be registered while also the trustee has registered the trust instrument with the Registrar General?
Okay. Thank you, Giselle. Maybe before I actually deep dive into the question that you've just asked, I want to just touch a little bit on the first question, just to give a wider view in addition to what Dr. Delit has said on the new changes in the trust law. So initially, us as practitioners, when we needed to register non-commercial trusts, for example, family trusts, even charity trusts, it was a little bit difficult because there was no legal framework for that. Because what the capital markets law provided for was that commercial trusts would be registered with CMA, and non-commercial trusts, it was a little bit hanging. So you just create a trust deed, have it notarized, and that was it. So this new law has put in that new element. Even non-commercial trusts can be registered with the RG. Now back to your question in terms of the properties of a trust. Of course, those are properties that are mentioned in a trust deed. Usually a trust deed or a trust instrument, as the law highlights, is property that is in the trust deed, which is like an agreement between. I want to make it a little bit simple for people to understand, people who are not with the legal, who don't have a legal background to understand it. So a trust instrument or a trust deed is almost like an agreement between the settlor or the promoter and the trustee. And in that trust instrument, he highlights what the trustee needs to do and what properties they should hold. And those properties can be immovable or movables. And immovable, that means like real estate. Immovable would range from equity shares in a company, cash, fixed income securities like the investments in treasury bills, bonds, etc. And why should this property be registered? This property needs to be registered, first of all, for transparency reasons, so that, let's say, for example, in a family trust where the settlor, who is maybe a parent who is expecting that the trustee will hold assets for future generations, whether they are young children or it should be clear that once it's filed with the Registrar General, no one will contest, no one will ever come to contest that that property is not managed by the trustees. But also for commercial trusts, for example, it promotes transparency, it avoids money laundering. And what was the third question that you asked?
It was actually that, but also I think from what you said, yes. I have a follow-up question.
Yes.
There's this, you mentioned about like the service providers.
Yes.
So I would like you to inform the audience, yes, about this new business service that is being promoted under KFC, yes, about trust company service providers.
Okay.
Yes.
Yeah. So trust and corporate service providers. It has been an existing service. Which is usually done by lawyers and accountants, but now there's a proper legal framework for it. And I think Dr. Delit touched on it. From the time the regulation will be passed, I think it's in its final process to be passed by BNR, there's a requirement that all corporate service providers and all trustees should be licensed by BNR. Those are the ones that are not licensed by CMA. So the ones that are licensed by CMA are those that will be engaged in commercial trusts that are supposed to list, like collective investment schemes, like investment funds. Those will be licensed by CMA, and all the others have to be licensed by BNR. So today, for example, we've been providing those services. The company law requires that for someone to register in Rwanda, they should have an address, a registered address, offices. They should have a local resident director. Sometimes when we say resident director, people feel Rwandan director, but as long as they are resident. So sometimes you find that foreign companies don't have anyone here. They don't intend to register an office here. They just want to create a special purpose vehicle to do business in Rwanda. So what they do, they use lawyers or accountants. So lawyers and accountants have been doing this work, but there was no proper legal framework. But also trustee services to act as trustees in all these. So you can register as a corporate trustee, or you can register as an individual trustee. So BNR licensing requirements, there's a regulation. It ranges from the fee you have to pay, you have to meet the fit and proper test, be credit free, not credit free, but have a good CRB report, etc. There are so many requirements that going forward that not any lawyer or accountant will just provide these services, but they also have to be licensed. Yeah.
Okay, thank you so much, Molly. Thank you so much for complementing actually what Dr. Delit was saying about why the assets should be registered, just to make it clear to comply, with these international regulations where you have to comply to know that there are no hidden assets that will be used in money laundering or other international crimes. Thank you so much. And allow me to now get to you, Ode Thibirungi. Also, we mentioned what Dr. Delit said, that this new law recognizes, talks about foreign trusts. And I would like you to explain to us the difference between these Rwandan trusts and the foreign trusts, and deeply tell us about the types that are under Rwandan trusts in this new law.
Okay, thank you, Giselle. Yes, as my colleagues have said, we have the Rwandan trusts and we have foreign trusts. So in Rwandan trusts, it is a trust that is has a Rwandan law as its proper law. We have what we call the proper law of a trust. Every trust must have its proper law. So if the Rwandan law and this law particularly is its proper law, then that's a Rwandan trust. And then we have a foreign trust is that trust that uses a proper law from another jurisdiction that is not Rwanda. For example, it can be a trust that is operating in Rwanda but uses Mauritius law as its proper law. So that will be a foreign trust. However, you talked about the types of trusts. There can be in a trust where a trust that is a foreign trust, but that trust does that type of trust is not provided by the proper law chosen by the settler. So in that case, it's going to use Rwandan law as its proper law for that particular trust, type of trust. But it is still a foreign trust. That's the slight distinction, where one uses the Rwandan trust has Rwandan law, the law governing trust as its proper law, and then the other one is from another jurisdiction. The Rwandan trust might be established somewhere outside Rwanda, but it specifies in the trust instrument that its proper law is Rwandan law. That is still a Rwandan trust. It might be established by someone that is not resident in Rwanda, but it still uses proper law as its proper law as Rwandan law. That is still a Rwandan trust. That's it is the difference. The difference is mainly the proper law of the trust. So the one is a foreign one uses any other jurisdiction other than Rwandan jurisdiction. Yeah, that's the difference. So when we go to the types of trusts in this particular law, there are three types of trusts provided in this law. There is the protective trust, and this is mainly done for the people who need legal protection, like some people that have not attained the majority age who need a legal protection, so the settler will create a trust to protect their property or inheritance, and maybe other people who are in that category, not necessarily children, but who need a legal protection, that those that are mentally incapable of managing their property. So this trust is created so that their inheritance or property does not go to waste. And they are not, in this one, their interest in that trust is protected. You cannot give it away to anyone, even if you are a beneficiary. It is provided in the instrument that your property is protected, and it is used as the instrument provides. We have another trust, which is the charitable trust. My colleague Mari talked about it. This one is created for charity purposes, and this one does not name the specific beneficiaries. It may be like for human rights protection. It could be for certain category of people, but the individuals are not mentioned. So when you're in that category, you benefit from that trust, but there are no specific names as beneficiaries of this trust. That is about the charitable trust, and we have another trust, which is the purpose trust. This one does not also have direct beneficiaries. It is created for a certain purpose. Maybe it could be, let's say, we want to construct, the settler might decide to do something for a certain community. Maybe we want to construct something that will benefit a certain community or a certain institution, or whatever the settler decides. It does not also have the beneficiaries, so it will be there for that purpose, as long as that purpose does not contradict the Rwandan laws, the culture. It is not against the public morals and order. It is also accepted as such by the Rwandan law. So those are the three main types of trust provided in this law. But there's so many types of trusts when you look at different jurisdictions. So in drafting this law, it was decided that these are the ones that can be put in this law, but this law provides flexibility, whereby I think Modi earlier talked about the family trust. So the law provides for other types of trusts that can be created regardless of not being provided in the law. But this time, when a settler decides to create that trust, that trust will be registered, and it will have Rwandan law as its proper law, as long as it is not contrary to this law and the other laws of Rwanda. It is also that flexibility is there, but there are too many types of trust. They cannot be put in one law. So the ones that are common are these three, but others can also be established in Rwanda. Thank you.
Yeah, thank you so much, Odette. Thank you so much for giving such a deep understanding to the audience about the foreign, for the foreign trusts, as you mentioned, that it's just the law, that the settler is free to choose the law to govern the trust, and that law that is chosen will qualify to be a Rwandan trust or a foreign trust. And also about the types, as you mentioned, that there are quite a number of types, that the law is so flexible in that way. And I think it's very necessary for the audience to know it. They might think that they are limited to those stipulated in the law, but when they want to open up another one. Just thank you so much, Odette. Let me now go to you, Eric. So they've been saying about establishment of a trust and what, but they also mentioned a trustee. And we'd like you to deepen on that and tell us about the role, duties, and powers of a trustee.
Thank you, Giselle. I'll first define the trustee, and then right after I'll go to tackle the duties, and then afterwards the powers of the trustee. First of all, a trustee, the trustee's role is to administer the affairs of the trust. So in practice, it means that the trustee is a legal person or a natural person to whom a trust property has been committed to administer for a third party, the beneficiary. Under the Rwandan law, it's stipulated that the trustee is licensed either by the central bank or by the capital market authority, depending on the kind of activities that they deal with. So in practice, it's worth to say that a trustee role is to maximize the assets, to minimize the liabilities, using the laws, and of course doing the best of his ability. Now, talking about the duties. Duties, first of all, duties, it's an obligation for the trustee to, it's an obligation he has to do. It's something he has to do. We have two types of duties. You have the duty, fiduciary duty, and then you have the general duties. Fiduciary duties, I would like to mention some because they are very important. The first one is the duty of loyalty. This one is important because the trustee cannot he cannot enter into a competition with the trustee he's representing. So it's very important that those two are separated. The other one is the duty for care. This is important because the trustee, then the law says the trustee has to take greater care of the trust property than his own property. It's very important. The other one we need to consider is the duty to act with diligence. So the trustee needs to act with diligence and to be promoting at the best as he can the interest of the beneficiaries. One last one is to abide by the laws and the legal instrument. Having spoke about the fiduciary duties, it's also important for us to tackle the general duties. One general duty is that the trustee, he needs to develop and enhance
the jurisdiction as the proper of the trust. That is also one of his powers. He can also restrict the exercise of the powers of the trustee. I don't need to go into the trustee, but because my colleagues have talked about it, but he might decide to restrict some of the powers of the trustee, and that is all done in the trust instrument. So from time to time there are changes and modifications to a trust instrument that is done by the settler. I think, in summary, that those are his powers over a trust that he has created.
Okay, thank you. Maybe a follow-up question. Are there minimum requirements maybe for being a settler, for being the owner of a trust? Are there legal requirements? Or any person just having assets can just create a trust and...
Yes, for a trust to be created, there has to be the property of a trust. So there are many, the trust property, there's what we call the validity of a trust. For a trust to be valid, there are requirements, including the trust property must be there. It must not be, maybe you cannot have the property that is a mortgage in a certain bank and then you put it in a trust. That is one of the conditions of a trust to be valid. And a trust cannot be valid if it contradicts the Rwandan law, this law and other related laws. And the trust, for a trust to be valid also, the trustee, to take off, the trustee has to accept that he's accepting that obligation of being the trustee of a trust created by the settler. I think generally that is what, there are other conditions that have to be met by the trustee, but mainly that is for the validity of a trust to exist.
Yeah, thank you so much. Thank you so much, Odeth. And allow me to now get back to you, Dr. Adelit. Odeth was talking about owning assets, like being a settler, but then I would like you to explain to our audience the benefits of owning assets in a trust, and also explain to us the uses of a trust and how a trust can be taxed.
Yeah, thank you, Giselle. So the benefits of the settler or the promoter to put assets for the trustee to manage them on trust. On my view, number one is the protection of those assets administered by a trustee on trust. So because, as we said from the beginning, so this law allow the promoter or the settler to put a asset, to hold asset on trust managed by a trustee. So, for instance, for the benefit of a person in succession. So I think, as one of our colleagues said, you don't know what will come in the future. For instance, those persons who will benefit from the revenues from those assets put on trust, instead of giving the right on the property, so it is good, on my view, to give them the rights on revenues coming from those assets. Because if no one wish to happen, but if one of the beneficiary, for instance, can misuse them, so the liability will just not to go beyond, above the interest that person has from the asset put on trust to be managed by trustee. So is to protect the asset for the future generation. So it allows those assets to be tied together and handed 2 generations together, enjoying revenues from those assets, but not having the full rights on the property. So they can't really misuse them in the future. So different uses of the trust also, as we said from the beginning, which is really what I believe is the attractive aspect of this new law, is now broad. So the trust can be used for investment as this unit trust. Also, it can be used, I think one of the colleagues is Odeth says you can use a trust for charitable purposes. So you put asset there administered by trustee, but for the benefit, for instance, of orphans or for those purposes, charitable or not. Protection of environment, so to benefit for a community. So all are the new uses we brought in this new law, which were not there before. So I think that is mostly if I can categorize the uses of the trust.
There is also powers when it comes to modify, when it comes to interpret, when it comes to also revoke a term in the trust instrument or the trust deed. So one first power that the judge has under that rubric is that it can impose a direction. The judge can impose a direction and impose it to the trustee and the way to go. The other way is that the judge can also decide to modify a trust instrument. He can also decide to completely revoke all the terms in a trust instrument. That's the other aspect. The last powers that he has, and then it's under his power to oversee the transaction, the court has the power to transfer a trust property. He also has the right to cancel the property, the cancel ownership of the property. He also has the power to order expenses incurred in a transaction to be paid outside the trust property. Those are the other three under his power to oversee the transactions. So thank you, Giselle. That's a kind of resume of all the powers that the court have in order to monitor and administer the trusts.
Yes, thank you so much, Eric. Yes, as they've been all saying that when you put your assets in the trust, that means you're seeking for protection. So that means also, from what Eric explained, even the court oversees in case there is a problem in the way your properties will be administered, then the court may intervene to ensure that the protection you're seeking in a trust is really ensured. Yeah, thank you so much, Eric. And our audience, I would like you to ask you to keep writing your questions in the chat box as we are ending our session with the last question that I'm going to ask Molly. We hope to ask you questions after this last question. So Molly, I would like to ask you that the law mentions that information to be filed with the Registrar General, including the information of different legal persons that are in the trust, the enforcer, the settler, the trustee, the beneficiaries, and we would like you to explain to our audience why is it necessary to have all those information filed with the Registrar General?
Thank you, Giselle. I think it's almost similar to the one that I had mentioned before of why trust details have to be filed with the Registrar General. So, as you've already mentioned, I think there are 4 or 5 players. Odeth already talked about the settler, who is actually the initiator of a trust, and talked about someone else talked about the trustee, and the trustee basically is the legal person, the main person in a trust. He manages the properties. He makes sure that everything is okay, the beneficiaries are protected, even though he has 2 other people or 2 other players who is the enforcer enforcer is supposed to make sure that also is like a second eye on the trustee to make sure that the trustee is fulfilling his duties. For example, he's not mixing the trustee property with his own property, or he's not bankrupt and all that. Basically, like being a second eye on behalf of the settler, but also the beneficiaries. Then coming back to your question in terms of why is it necessary for all these details to be filed with the Registrar General, it's because trusts, they've already mentioned, trusts can be used as investment vehicles, especially for the collective investment schemes that are already mentioned, or investment companies. So there are a lot of dealings that require transparency, so that if any public authority needs access to information, they're able to get it. And the kind of public authorities that are mentioned in the law is law enforcement, police, investigation bureau, RIB, financial intelligence services, the regulator, and all other interested parties who have to make sure that in case there's a dispute, they're able to access this information. Because there are times there are disputes, and Eric has just mentioned the role of the court. Sometimes even any interested party, whether it's a beneficiary, can file to court to request the removal of a trustee, for example, or can indicate things that are not right. So public authorities should be able to have access to all this information. So in brief, that's why they have to be registered with RG.
Yeah, thank you so much. Thank you so much, Molly, and thank you so much for our panelists. I hope the audience now understand what a trust is, how they can establish, any willing person can establish a trust, and why is it necessary to have properties under a trust, and why it is encouraged, as Dr. Delit was saying. And I would like to, if there are no questions, I would like to thank our panelists, and also let our audience know that we are here for you. If you have any question, any further question about a trust, how you can open up a trust, you can reach out to us, Rwanda Finance Limited, through our different social medias, or reach out to us using our email info@rwandafinancelimited, rwandafinance.com. Thank you so much, our panelists, and I think we can end the session here. Thank you for accepting our invitation.
Thank you.
Thank you.
Thank you.